We present a lecture on the evaluation of damages in a business case by Hillary Rodham, attorney at law.
I suppose one of the most remarkable things about trying to talk about evaluating damages in business litigation is that there's really only a couple of things you could say if you were to ask someone right off the top of his or her head to comment on it. One would be that you just get them as high as you can if you're representing the plaintiff, and the other is that you try to keep them as low as you possibly can if you're representing the defendant. If you read the literature that's available, and there's not very much, that's about what it comes down to. Do you either overestimate or take your chances with trusting the jury? Do you try to discredit liability and take your chances with damages? Well, those questions, I think, deserve a closer look than they've been given, perhaps since 1935, when Charles McCormick wrote his handbook on damages, and there really hasn't been very much since then. Just briefly, McCormick posed four questions about damages. First, he asked what elements of a party's loss, injury, or grievance will be recognized as grounds of compensation. Secondly, what formula of measurement is to be used in fixing compensation for recognized elements of loss, such as using fair market value or value in use. Thirdly, what are the limits on the application of these formula to recognized elements? Certainty, contemplation of the parties. And fourthly, what procedural rules regulate the manner in which counsel can plead and prove the elements of his damages, and then what are the procedural rules by which the appellate courts judge how well he or she has done. Now, since 1935, there have been remarkable changes in the area of damages, but they have not, as I've said, been given very much currency or even very much comment in legal literature or even among the practicing bar. Evaluating damages is still pretty much an instinctual thing. What does it look like to you? What do you think you can get? This afternoon, I'd like to talk about generally what we look at when we begin to evaluate a case to determine what kinds of damages we're going to ask for, and then how we prove them and how we persuade the jury, and then focusing on two particular areas that have developed since 1935 in the area of business litigation, and that is lost profits and punitive damages. Before I begin even with the general discussion about what to do when a client comes in and says, I've got a case and here's what I want, I think we should really expand our thinking beyond just damages, because in business litigation, like any other kind of litigation, in practice really more than in personal injury, for example, we're talking about outcome. Damages should not be limited to just the idea of money reimbursement. They should be thought of in terms of a context. What kind of outcome do we want for our clients? And how do we go about achieving it? So that it's combined with some kind of other relief, injunctive relief, for instance. It's always thought of in line with what sort of settlement we can begin negotiating. One of the problems, I think, with many commercial litigators is that they're terribly unimaginative. In walks a client and says, I've had a rough time with my competitor, or my contract has been breached. Here are my damages. And he lays down his invoices or other evidence of liquidated damages, and his lawyer says, terrific, let's see if we can get it. And doesn't think much more about what else is in that case that I can turn into damages, or what other kind of relief can I ask for based on the facts that have been presented. So keep in mind, when I talk about damages, I'm really talking about outcome, because that's what we're aiming for. All right, so beginning first with the client who comes in and says that he has some kind of a case, a grievance, an injury of some sort. One of the first things that needs to be done in commercial litigation, just as in other sorts of litigation, is an evaluation of the client. Now, many of you will represent in an ongoing capacity various corporations or individuals with business interests. You will already have an idea of who this client is, why he's coming in the door with a particular problem. But in many other instances, you will not. The first time you will have contact with the client will be when he arrives at your office and claims to have some injury that he wants you to avenge for him. It's very important at the beginning of your evaluation of damages that you evaluate your client. What kind of a person is this? What kind of a corporation is it? Exactly what's going on in this partnership that they claim to have these grievous injuries? Are they acting out of spite, which all too often is overlooked as a motivation in the business world, much to the chagrin often of attorneys who take on clients only to discover that there really is less than meets the eye in what the claim happens to be. So evaluate your client. Find out what it is he really wants as well as what he expresses. One cannot evaluate damages unless one goes very deeply into the subject matter of the claim that the client presents. I mean, how do you know what kind of a business this person has when he walks in and tells you unless you completely examine it? And by that I mean not just an examination that is narrow and focused already with the preconception in your mind as to what the cause of action is and what the probable damages will be. Instead, launch a wide-ranging examination. Someone comes in about a breach of contract, be sure to look into what their functioning as a business has been over the past year. Find out what the market is like. You may have an unfair competition claim as well as a breach of contract. You may even have an antitrust claim under the Sherman Act, Section 1 or maybe Section 2. But you won't know that if you take the client's presentation of the facts as what you will begin to evaluate damages based upon. So first, evaluate the client. Secondly, evaluate much more thoroughly than usually we do, perhaps, just in the ordinary run of the case, what is being presented to you. Now, in personal injury, we're more used to going into great detail about who this client is because we know that the claim for damages will rest very often on the credibility of the plaintiff. It's the same in commercial litigation, and that should not be forgotten. We need to go in and find out who this person is, what kind of a business it is, so that we can determine what sort of a claim it is, and then go forward to determine what kind of damages may be requested. So you have a possible damage claim. What then is the next step? Well, obviously, you've looked into the law. You've determined what kinds of legal standards you've got to meet in order to make out the claim. And you begin to try to put together all the various segments of this damage claim that you're going to be requesting. There are a number of factors to look into. First of all, should it be brought in state or federal court? What difference will that make, not only to the substantive law that's applied to the cause of action, but also to the request for damages? It may not make any difference at all, but it may make a difference in some instances. Going back to the unfair competition claim, it may be that you can pend it onto an antitrust claim and treble your damages. So instead of going in on the front end to a state court action asking for breach of contract, unfair competition, you go into federal court and you've already upped the damages that you may be able to ask for. In addition to evaluating the state or federal question, there are conflict of laws questions that should always be considered that may bear on the question of damages. You need to evaluate, just as carefully as you do your own client and his claim for damages, that of the opposition, who the defendant is. What kind of company or what kind of individual is this that you're going to be asking for damages against? What share of the market do they have? What kinds of practices have they engaged in the past? What kind of a target are they as you begin to put together your case? Once you get the basics and the detailed basics as to your claim and you begin to form an idea of what the sort of damages that you're requesting may be, you're going to have to face one of the issues that has been discussed without any resolution since 1935, and that is, do you ask for exactly what you can prove, or do you ask for more? Now, you can read the few commentators who write about damages, and you will find that they fall very obviously into two classes. There are those who insist that you're foolish if you ask for more than you can prove because you undermined your credibility. There are others who say you're equally foolish if you don't ask for much more than you think you can prove, since the jury will cut and compromise anyway. There's no way to give a general answer to that question. It depends again upon the particular kind of case. Lots of times in products cases, plaintiffs' attorneys hurt themselves very badly by asking for outrageous sums. In a case that I defended some time ago, known in my mind at least as the rat's ass case, since it involved the rear end of a rat that ended up in a can of pork and beans, which I argued was probably to the benefit of the plaintiff since it was the only protein that he could find in the can. The plaintiff asked for $150,000 without any medicals or any other particular damage except the disgusting spectacle of the rat. And I think it hurt him, and it seemed to have hurt him with the jury as they filed out. They gave him what we'd offered to settle for and claimed that, you know, it was a pretty bad thing to have happen in your kitchen, but it sure wasn't worth $150,000, and it sure didn't seem to make out the sort of moral argument that plaintiff's counsel made at the closing, that this was a message that we had to send to corporate America. So you have to be careful about overreaching yourself, even at the point of writing the complaint. What kind of damages are you going to ask for? On the other hand, to be too timid may be a real disadvantage, not only in trial, but also in a negotiation and settlement. Again, it's true that credibility plays a great role in negotiation and settlement. You're obviously going to get someone to a table faster if they think you can prove what you alleged you can prove. On the other hand, you don't want to sell your client or yourself short. Another aspect about the client relationship in evaluating damages is once you know what kind of a client you have and what the case means to the client, sometimes that influences you in what to ask for. It may, in some instances, determine whether or not you bring the case, but it also may determine how much you ask for if you do bring it. If this case means a great deal to a client, if somehow it stands for principle, even though you don't understand the principle, it may be that you're going to have to ask for more than you would ordinarily ask for. I finished a trial not so long ago in a case that I just kept telling our client not to bring, that it was a total loser. And he kept telling me that it was principle and morality, and the younger generation didn't understand that you had to make your competitors live up to their bargains, and on and on. And we took it to trial, and he turned out to be right, that it did have a kind of Old Testament flair to it, and he was awarded everything he asked for, but it wasn't rational. There was no way you could really predict that in the beginning. In fact, I predicted just the opposite, that it was a terrible case, should never have been brought, and yet we did win it. So it's a matter of individual judgment. What do you think you can get, and what do you think you can prove? There are really several steps in the process once you get to writing out the complaint. The first, as we've just discussed, is setting out the amount, going through that tortuous process of deciding whether to overshoot or try to aim exactly where you think you can come out. The second is proving your case. Now there, you again start with your own client. Once a complaint is drafted, I've observed, and I'm sure we've all done the same thing, we narrow our focus. We begin to ask our client even questions that seem directly pertaining to the complaint, relevancy, obviously. But sometimes with your own client, more than anybody else, you need to see everything there is to see, whether or not the client thinks it has anything to do with what he's hired you for or anything to do with this complaint that you've drafted. You have to keep demanding that you see everything, the financial records, the production records, the tax returns. If it's a complicated case, and if these matters may bear on the proof that's to be made, you have to know about it, and you may not even think of to ask for it because it doesn't seem like it would be admissible. It doesn't seem like it would ever enter into the proof at the trial, but it may. Sometimes it's a good idea just to ask your client to let you come over for a day and just as if you were the opposition, sit down and go through everything, only without the constraints that discovery might put on the defendant or the plaintiff, whoever is the opposition. Go through whatever might strike you as being possibly in any way touching upon these issues. And you may be surprised at what you discover. Among the things that you are going to have to prove will be the various elements of the damage, obviously. You're going to have to be able to make out the case. Now, with liquidated damages, that's not all that hard. But with matters like lost profits, as we'll discuss in a minute, it becomes very difficult. You have to go through the gyrations of building something out of what's available, which may or may not look as though it's directly applicable. So you have to go through the production data and the sales data, the earnings figures. You have to get an outside party as well as an inside one to evaluate them. Don't just rest on your own clients and his personnel decisions about what is or is not the meaning of these figures. Get somebody outside to be sure that what you're being told about the figures, the auditing reports and all, is what would be seen by an outside observer, by the opposition's counsel, for instance. The third thing you have to do, you have to think about doing when you're proving damages, is interpreting the damages. Now, when you're in trial and you've begun to put on your case about proving the elements of your damages, it's not going to mean very much to the jury unless it's very black and white. But if you're talking about lost profits or punitive damages, you have to interpret these figures as they come out and demonstrate to the jury why they're important, where they come from, what their basis is. You often use expert testimony in this regard, but you also use your own client. You need to be sure that the way he explains these various figures is understandable. And so you have to be the translator or the interpreter for that data and information to the jury. You also have to illustrate your point. Again, in commercial litigation, unlike personal injury, many of the devices that are open to a trial counsel are forgotten or overlooked. Very often you'll go into a commercial case, there won't be an exhibit around. There certainly won't be anything as dramatic as demonstrative evidence or videotape. But that's where imagination comes in. That's where taking those cold, boring figures about production data can really be changed into something that the jury can relate to. Now, it's pretty hard to get very emotional about production data or to think that you're going to capture anybody's attention with it, but if you don't try, you'll never know. Sometimes in commercial cases, the lawyer will go so far as to bring with him a magic marker and a cardboard piece of paper, and as his executive manager in charge of finances or whoever the witness is talks, he will say, and so you said that your production figure was X. Is that, you know, write it up on the thing and then write the next one down. And in that way, try to demonstrate, illustrate for the jury what these figures are and how they add up to what the claim is. I think that's a, you know, I just think that's almost not as good as doing nothing, because it doesn't have the impact that having prepared exhibits will have in commercial litigation. I would urge each of you to figure out ways of imaginatively presenting these cold, boring figures that are often the subject matter of damages. Another issue that you have to think about as you're preparing to evaluate your damages and as you're evaluating them for the jury, because evaluation is both pre-trial and during trial, is your argument, both in the beginning and at the end. I think it's very good advice that a opening statement can include a description of the damages, because it won't be so shocking when you begin to talk about big figures for lost profits. The jury will be prepared that this case is not just about one corporation or one person doing another wrong. It's about money. It's about maybe substantial sums of money. You begin to kind of accustom them to talking in large terms. You begin to try to give them the idea on the front end that this is what you're going to prove, and you're very clear about it. You're not asking for some pie-in-the-sky figure. You've got your facts. You're going to be able to prove them, and here they are. Some lawyers won't talk about damages in the opening statement, instead preferring to talk only about liability and try to set the stage. And then in closing argument, after summing up their liability points, then going into damages. Again, it's a matter of style. Each lawyer has his or her own way of doing things, but I think it's very effective on the front end in a very sort of careful way to lay out what those figures are that they're going to be hearing about during the next day or so. And finally, in your instructions, how are you going to prepare your instructions to maximize the effect of your damages? Probably the best way is to use special instructions, if you can, to break them down into as many discrete elements as possible, to give the jury a chance, as someone said, to ring the cash register more than once, because when it rings more than once, it rings more. And you give them an opportunity to think about those individual elements one more time and to aggregate them, rather than sort of making a guess based on what seems to be fair and looking at all the figures and the exhibits, hopefully, and then saying, well, round it off and that seems to be it. Force them to focus on each and every element so that they have to, if they're going to compromise, compromise on your terms, not on whatever terms they may come up with. So basically, we're talking about the pre-complaint process, the setting of the amount in the complaint, the proving of the damages through your own discovery and then at trial, interpreting those damages for the jury, illustrating them, arguing effectively about them, and framing instructions that will maximize your theory about damages. Now, two of the areas that have evolved since 1935 and are more interesting than a lot of the other more cut and dried areas of damages in business litigation are lost profits and punitive damages. The proof of lost profits is something, again, that requires some imagination. It normally is based principally on loss of income or loss of business opportunity, and other avenues of loss proof are kind of overlooked. But there are a number of ways to characterize loss. It may be that the whole business, its value has in some way been diminished. If that's the case, let's see if we can characterize it and then prove it. It may be that loss of business opportunity can be seen in a couple of different ways. It's not just the loss of one particular job or the opportunity to gain one particular new product. It may be the loss of a whole market. So don't think in small terms. Expand your analysis as far as you can responsibly take it. You need, again, with lost profits, like in any other evaluation of business damages, to study the business. You need to know as much about that business as your client. All too often, the party that comes in representing a business feels that he knows enough to make his claim. He knows enough to make his damage proof, but he should know more than that. He should know where he has information that he can discard because he's acquired it and evaluated it and knows he doesn't need it. He needs to understand the accounting methods that are used in the business. He needs to be sure that he understands the goals in the business. Is it a new business? It's expanding rapidly, so that the loss of some kind of business opportunity for 2 months could be much more dramatic to it than to a long-established business where 2 months may or may not be very critical. He needs to understand the effect of inflation on that particular kind of business. Some businesses are hit much harder than others. He needs also, with lost profits, as with any other kind of damage evaluation, to create some sort of theory around which he's going to argue his lost profits. What is it about this particular business that makes lost profits so important? What's happened? How can it be humanized in some way? If you have a case that involves, for instance, the stealing of trade information or the lifting of confidential customer lists by employees who leave, make that as dramatic as possible. Begin to think about what that means, not just in money terms, but in human terms. One of the things that hardly ever happens in commercial litigation, at least I don't know, it may, but I've never seen it, is that the plaintiff puts on the people who are affected by the loss of profits. It's not just the managers who get up and talk about the dry figures. It's the foreman who was laid off for 2 months because this business opportunity was taken away. It's the worker who was laid off. It's the person who wasn't laid off but had to cut back on the hours worked. There are personal problems, and there's an element of human drama in even the dullest corporate case that needs to be brought out to make the jury feel that it's alive, that it's not just something that has to do with accountants and economists and market analyses. So try, when you're developing your underlying theory, to figure out, well, how could I explain that to a child? If your son or daughter said to you, "What are you doing?" And as some commercial litigators do, they sort of mumble, say, "Well, I'm trying a case, you know." They don't really explain it because it's sort of hard and they think it's arcane, or as others do, they assume an attitude that it's impossible to explain to anyone who's not on their level, whatever that happens to be. Well, think in terms of explaining it to a child. How would you tell the child, this is a case about people who did this? And then you can begin to develop your theory. And that theory will carry you through all the way to your closing argument. Now, in lost profits, as with any other element of damages, once you have your theory, that will determine how you proceed to prove your claim. So you've set out your amount based on your theory, and you're going to prove your claim. Well, what do you need to look for? Well, you obviously need, as I've said before, to get every business record you can find that might possibly relate to what you're doing. Sales data, direct and variable costs, the burden rate, the depreciation schedule, everything you can think of that might have some impact. You also need information about the market again, but not just about your plaintiffs or your defendants' share in the market, but about the market as a whole. You need to discover information on your own from the Department of Commerce or the Department of Agriculture. Use the Freedom of Information Act in your state, or the Federal Freedom of Information Act, which is 5 U.S. Code 552, to find out what is going on with other people in the market, what the competition looks like. Find out, if you can, from friendly competitors, if there are such things, what their sales records were like, what their year-end financial reports read. If you don't have to subpoena them, then the opposition doesn't know you have them, and you can make whatever use you wish of them. You also have to begin to estimate the damage, the real damage. What is this loss of profit actually translate into? Here you have to be careful that the amount that you come up with squares with every other document that happens to in any way bear on your client's financial situation. We recently had a case that alleged terrific loss of profit plus several other claims aggregating to about $1.6 million, and the loss of profit was based on pro forma statements prepared by the defendants. It was a counterclaim by a defendant. It was prepared by the defendant's accountants. Yet when we discovered the tax returns, we saw continual reports of losses. Now, there may or may not be an explanation for those losses, but the jury couldn't quite understand how the losses on the tax returns squared with these pro forma statements that projected future profits that were just astronomical. So you have to coordinate the kinds of information that is going to be available through discovery to the other side. And you have to reconcile them if possible. You need an explanation as to why the year-end report or the tax return doesn't square with what you're claiming has happened to the profit structure of your client. You need to keep in mind as you go and put together these estimates and begin to prepare the documentary proof that all of it is probably going to be discoverable, unless it fits within the attorney-client privilege or the work product privilege. So you need to be sure that what you're putting down on paper is something that you won't mind coming out in court, being used against you, and you'll understand how it can be explained away if it in some way undermines the theory of your case. Once you have this information, you need to figure out ways of illustrating. Now, in lost profits, like any other kinds of cases, the more graphic you can be, the better. The more illustrative of what it is. That, again, makes things clearer to the jury. It makes it clearer to your own witnesses. One of the things that you can do for your client, which all too often lawyers do for themselves and don't share with their clients, is to do simple things like put into chronological order all these vast documents that you have and cross-reference them in some other form that may be useful to the client. Sometimes the client does not even understand what it is he's turned over to you with all these documents, or how what he's told you over the last several months fits into the picture that you're putting together. Often the preparation of one's own witnesses consists only of explaining to that witness what he's going to be asked on examination and then running through a kind of rudimentary cross-examination. I think that's just almost unforgivable to put someone in a witness position without doing more than that. Obviously, more preparation with examination and cross, but also let the witness in on the theory. Let the witness see the proof that you're going to be putting forward. Now, again, you have to exercise some judgment. If you've got a witness who There are other kinds of suggestions for illustrating. So keep in mind you're illustrating not only to the jury, but you're illustrating to your own client and the witnesses that you will use when you put together these exhibits. One of the things that you should also remember is to submit your exhibits to opposing counsel. Sometimes attorneys try to finesse that because they feel like, well, if they don't have to do it, then the surprise element won't be eliminated, and they can probably argue and get them in because, after all, it's just reasonable within the scope of what's appropriate. But recently, I've had a chance to observe an attorney who showed up with his exhibits and had never shown them to one of my colleagues and myself who were trying this case, and wanted to use them in his opening argument. And what it was an outline on 4 large cardboards of the theory of his case, broken down as he wanted the jury to understand it. A very clever and interesting way to approach a question of complicated damages, but he hadn't shown it to anyone. And it obviously was prejudicial, since before anything was put into the record, he had already attempted to impose his theory on the jury, using in those cardboard exhibits various elements of damages as characterized as he wanted them to be characterized, such as this is the point at which the plaintiff breached the contract, or those kinds of efforts. It wasn't allowed in, and it seriously undermined his opening because that's what he had prepared around. So show your exhibits, be sure you're not going to have any trouble getting them in. Oftentimes it's useful to use as exhibits, by making them into transparencies, documents that are already within the scope of discovery. So there can be no claim of surprise. It's just the visual effect that upsets the opposite counsel. It's the fact that this piece of paper, which had been given to him months ago, is now shown up on a large screen for the jury to focus on. But that's too bad. I mean, that is part of the discovery, and it may be that you can use those kinds of documents in a visual and dramatic way. So you're illustrating, and you also need to interpret. Now, using experts in the area of lost profits is essential in many instances, whether the expert be one of your own witnesses, an employee of the client who is able to explain his own financial data, or whether you bring in somebody from the outside. If you can afford it, I think you should always bring in somebody from the outside to evaluate your case anyway, to let you know what the weaknesses in it happen to be. You may not want to use him as a witness after the evaluation is done, but at least you will have the benefit of whatever information he can give you. One of the most important things in proving loss of profits with your expert, as you use him to illustrate and interpret to the jury, is that he concede that there are different ways of evaluating loss. You can do that very smoothly, very quickly, and it doesn't open up a broad area of cross-examination that becomes the focus of, isn't it true, you know, Dr. X, that there are other ways of evaluating loss, and you didn't take those into account, did you? Let him say there are other ways, but he chose this way because it's better, because that's what he's an expert in, because it works in this particular industry, whatever the explanation might be. But yes, there are other ways. If you do not do that, you do open up a tremendous opportunity for the expert to be cross-examined and perhaps discredited. One of the other areas that will be opened up on cross-examination is that of the underlying facts on which the expert based his projection of lost profits. What did he look at? What information was he given? How did he make his judgments about what information he wanted? That's proper cross-examination. That's another thing you should do on direct. Lay it all out. Take the jury step by step. They don't know how to evaluate lost profits. Not very many people do. So let your expert tell them how it's done. You look at these figures. You ask these questions. And here's how you proceed. So again, that's already established. Then let the cross-examination be devoted to what may appear to be nitpicking as to whether or not, after the expert has gone into great detail about the underlying facts he took into account, he took that particular fact into account. So establish your own expert's credibility as early as possible and allow him then to be better able to withstand cross-examination on damages. Another thing is you have to prepare your expert not just with what you want him to say about the loss of profits, but provide him with all the information that is at your fingertips as to the documents that might be brought in, so that it's not just your client's accountant who may be asked about the discrepancy between the tax return and the pro forma. It's the expert as well. Don't leave him out on a limb trying to explain something that he has no knowledge of. Give him every opportunity to have the documents and the information so that he can evaluate it and can better present what you want him to present. Now, in lost profits, I guess finally, the thing that you want to do is to craft your argument and your instructions so that you take the jury through the steps again, one by one. In closing argument, particularly, it's important to concentrate on damages. Now is the opportunity for you to set forth your evaluation and to use the steps that you've gone through and that your witnesses have gone through in reaching the point at the aggregation that you want the jury to do. The same thing with instructions. You want the court to give you as much help as possible, obviously. In some jurisdictions, that includes the effect of inflation. It may also include the effect of taxes, which is another area for cross-examination about projected lost profits. But think about your instructions and try to make them as specific as you possibly can. Now, punitive damages is another area in business litigation that I think is too often overlooked. Of course, it's been traditional that you cannot expect to get damages for a corporation, for instance, for psychological harm. But very often when you bring cases, you have combined parties. You may have a corporation and the individual who happens to be the president. So it may be possible to inject an element of psychological suffering, if there is such a possibility, into the complaint on the basis of the human being who's there. But it also may be possible for the corporation itself to receive punitive damages. There have been a number and a variety of kinds of cases in which that has been possible recently. misappropriation of trade secrets, civil conspiracy, the piracy of records, slander of title. There's a number of ways in which punitive damages may enter into your evaluation. And I think it's important to think about whether or not there is any way to make a punitive damages claim in good conscience, because one of the things it permits you to do is to inquire into the financial worth in greater detail than you might be able to based just on the other damages that you have. You are able to go in and find out what this corporation has really been doing for the last several years, because that is one of the bases on which the jury is permitted to assess punitive damages. There are really 3 points that need to be kept in mind when you think about punitive damages. The first is, in order to claim it, the character of the defendant's acts has to fit within whatever statutory or case law language is appropriate. It may be that it must be oppressive or malicious or fraudulent or outrageous, but there has to be a way to characterize that action. And it can't be just because your client is mad as he can be. You have to be able to do it objectively. Is that something that really makes you outrageous, or is it just because your client's been carrying on a running feud with his competitor for the last 20 years? You don't want to be embarrassed. You don't want to destroy your own credibility with a request for punitive damages, even in the settlement phase. So think that through carefully. Secondly, you have to think about what kind of harm was actually caused or intended. I mean, really, what did the defendant, what did he do? Again, is it just because your client has an exaggerated sense of his own worth that he's claiming he's been harmed beyond redemption, or is it objectively something that can be proven? Among the things that you want to look to is the traditional standard, which is that the request or the amount of punitive damages awarded must bear some kind of reasonable relationship to the amount of actual damages. So if you're going to be asking for punitive damages, you need, again, in the very beginning, to put your case for actual damages together as tightly and well as possible, because that will be the underlying figure on which any punitive damages are based. Now, the whole issue of punitive damages raises policy questions. They're called punitive in some jurisdictions, exemplary in others, because they're supposed to not only make your client feel good that he in some way has avenged himself, but to serve a public policy, serve as a deterrent to others who might engage in conduct that society believes is outrageous. So you have to be able, again, to take this harm that is caused or intended and generalize it. It can't be just because your own client or you on behalf of your client is outraged. This has to have a more universal appeal. It has to strike responsive chords in the jurors. There have been cases that have been upheld in which the amount of punitive damages or exemplary damages were much greater than the actual accorded, because the act seemed to be so offensive to the jury and to the Court of Appeals. So it can happen that there's no reasonable relationship. What you have to do is to try to make out your as effectively as you can, to try to in some way inject some human feeling. Don't just ask that you get it because it's the right thing to do. You ask because the jury also believes that that's the only way that they can serve justice. It sounds a little dramatic, but if you're going to be effective with punitive damages, you have to attempt to do that. The third point is you do have an opportunity to establish the wealth of the defendant. You're able to do it through discovery initially because you make your claim. Now, the defendant, for those of us who occasionally defend defendants, should resist this, of course, as much as possible, and there are various routes of doing so. One can claim that a prima facie case for punitive damages must be made out before information about the defendant's wealth or net worth is revealed. Some jurisdictions uphold that, others do not, and allow, once a supportable punitive damages claim is made, supportable may be judged on the basis of a pretrial conference or on the basis of some other effort on the part of the defendant to strike that element in the complaint, which is overruled. So the court may make some preliminary determination before you can go into net worth and wealth. But it's certainly worth trying, because it gives you a tremendous discovery tool, not just for punitive damages again, but also for your actual damage case. You will find out things that will be very useful to you if you're permitted to discover that. One of the things that is sometimes forbidden for discovery in the punitive damages area is net earnings. There are distinctions made between net earnings and net worth, and you'll have to check your own jurisdiction to determine. A final point about punitive damages is the possibility in business torts of invoking what is called the complicity rule. And that's basically a kind of master-servant rule that applies to corporations in this area, which is that, you know, employers are vicariously liable for torts of employees, and that in the majority of our jurisdictions, if the employee committed a tort within the scope of his or her employment that would render the corporation liable for compensatory damages and would also render the employee liable for punitive damages, then the corporation itself may be liable for punitive damages. So sometimes when you're dealing with what looks like a kind of ordinary business tort case, some action on the part of some particular employee, again, think through to yourself whether or not punitive damages against the corporation may or may not be appropriate in that case. Now, there is also a minority position. You have to, again, check the law in your jurisdiction that requires something further than just that kind of circular proof, and that is that there has to have been some authorization by the corporation or post-act ratification. It may be that in some jurisdictions, even a management employee may or may not fit within this category. So you'll have to check whatever the law may be, but keep it in mind as one possibility. Now, what's the defense argument against punitive damages? Well, the most obvious and most used one is that it's a windfall, that it doesn't serve any social or cultural or economic purpose to go ahead and to award damages that have no relation to the harm, as the defendant would argue. The windfall argument may be effective in whittling down the damages or in eliminating them, but the defense counsel has to be particularly sensitive to how effective the plaintiff's counsel has been. To make an argument that punitive damages should not be awarded only stresses the whole issue of punitive damages. It also raises the possibility that the jury will have a backlash against you as defense counsel for asking them or telling them that they cannot relate to or feel for these people who've been representing these interests who claim to have been outraged. So one must be careful as to how the argument is made and to watch the jury's reaction as punitive damage claims are laid out. Now, the lost profits and punitive damage claims are probably the two areas that most deserve your attention, because most of the others within the damage field and business litigation are pretty straightforward. But I thought I would briefly run through, as we're finishing up here, some of the other issues that you need to keep in mind when you're evaluating damages. One, of course, is that it's not just in lost profits, but it's in every other area that you must be as certain as you can. The principle of certainty, that damages are not remote or speculative or contingent, goes again to the proof. I mean, how certain can you be? How certain can you make the jury be? The other is that you have to be willing to guard against or to defend against the arguments against your damages, such as mitigation, such as your inability to minimize whatever loss it was that you are now claiming, or to prevent that lost business opportunity. You have to take that into account when you're evaluating the damages. How does it look from the other side? How would they best be able to pick holes in it? And that will be one of the areas that will be concentrated on. The third principle is market value or fair market value, or however value is defined. I mean, what is it that you are going to be able to measure your claim against? And different situations require different standards. It's usually lumped under the heading of value, but it may be that you will use fair market value in one and not in the other. One of the issues in one of the workshop cases this week is the valuation of stock, always a difficult problem, where, especially in a closed corporation, we're talking about stock. How do we value that stock? A fourth point to keep in mind is interest as damages. If you had had that loan that was interfered with and you're claiming interference with prospective business opportunity, What could you have used that money for? How could you have invested it? What sort of earnings could you have realized? What kind of interest can you ask for based on the damages that you claim to have suffered? Final point is fees and expenses. Is it possible within the claim that you're making in your jurisdiction that you can recover your fees or your expenses? There's currently a great debate going on, I don't know how far it'll go, as to whether or not we should follow a British or Canadian model of including fees and expenses as one of the elements of damages more as a matter of course and permitting recovery to the winning side. That may be an issue that will come up in the next several years, but you should check the specific statute that you're operating under or the case law to determine whether that's possible in the case that you currently have. So finally, I would suppose that in summary that evaluating business damages can be whatever you want it to be. You can do it with as much care and effort as you would anything else and try to go into it as deeply as possible. That will depend on many things, your caseload and the value of this client and the particular interest you have in the claim. But I think that if you can keep in mind that there are a variety of ways of approaching the evaluation process and that it should not remain just a kind of instinctive gut reaction that, well, this looks like a $2,500 case, or have your secretary fill in $100,000 in your form complaint, you may find that you will come up with more imaginative and creative ways, not just of evaluating damages, but of trying your cases. And that, if nothing else, will make your practice more interesting for you. Thank you.